All right, you got your speaker? You got your speaker? Can you hear it? Deputy Everett, are we ready with anyone in the jail court?
Yes, sir, we are.
Who would you like first?
Sammy Molina.
Sammy Molina, CR 18104, motion to revoke. Go ahead, Mr. Schmidt.
Judge, we reached an agreement with the state. The state's tendered a motion to withdraw their motion to revoke and ask that his conditions of community supervision be amended. Pertinent part, the amendments consist of the additional fees associated with this action, as well as a 2-year extension on his probation period. And he is also going to submit to safety as a condition of his community supervision, and then ISP upon release.
Thank you, Mr. Schmidt. And has this been approved by the probation department? Do they support or not support this proposed plea?
It's my understanding, Judge, that Mr. Molina's probation officer was Larry Gann. And it's also my understanding that he was contacted pertaining to this. It's my understanding he approved it, but the DA's office can speak for that.
Judge, I believe the probation department is supportive of this.
Okay. All right, Mr. Molina, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, you can lower your hand. Mr. Molina, do you understand what Mr. Schmidt just announced to the court?
Yes, sir, I do.
You understand that if the court grants the state's motion to withdraw and amend your conditions of community supervision, you will be required to attend the substance abuse felony punishment facility rehab program, that your probation will be extended for 2 years, and you will be responsible for the new financial obligations based on the filing of this motion. You understand that?
Yes,
Is that what you want the court to approve?
yes, sir, I do.
Has anyone threatened, forced, or pressured you to make you feel like you had to make this agreement today? Are you pleased with Mr. Schmidt as your attorney?
Yes, sir, I am.
And you feel like you've had enough time to come to this decision today, is that correct?
Yes,
And Mr. Schmidt, you believe that Mr. Molina is competent to enter into this agreement?
I do so, yes.
All right, then, based on the agreement of the parties and the recommendation of the Community Supervision and Corrections Department, the court will grant the state's motion to withdraw the motion to revoke filed in this cause. Court will amend the conditions of community supervision of Mr. Sammy Molina to include substance abuse felony punishment facility, 2-year extension, and the court will order Mr. Molina to pay the increased or additional which will result in an increase of financial obligations on the basis of the filing of this motion to revoke.
Thank you, Judge.
Thank you, Mr. Molina. Yeah, take it. You might be able to pull it all the way down there. Mr. Manning, who are you ready on?
Yeah, Mr. Ozuna.
Ozuna?
It's just, I was provided with a copy of his prior indictment. We have already done arraignment or waived arraignment on that. My understanding was that he was indicted on a new case. I don't have that case number, nor do I have an indictment, but if the court can get a hold of one, I'd be willing to waive indictment here on the record.
All right, let me see. I wasn't able to connect to the system earlier today. Let me see if I have any luck this afternoon.
Judge, I have it if you allow me to share my screen.
Yeah, let's do that. Give me just 1 second. All right, go ahead, Mr. White.
Judge, if you could scroll real quick.
Scroll up.
That's it, yes. Can you scroll down? Your Honor, Mr. Ozuna, we're getting some bad feedback over here. Mr. Ozuna's name is not spelled correctly. His middle name is ELUETRIO. He understands the charge, he understands the range of punishment, and this time he pleads not guilty, and we request to be set on a pretrial with the previous case, which is the 282. Judge, I'd also make an announcement on 282. I've requested certain discovery on that case. Ms. Curry provided me information this morning that she requested that at the end of October from DPS and has not received a response since then. And so I may need to, in preparation for our pretrial, we may need to file some type of motion to compel discovery so we can get that from DPS. But it is a forensic examination of video security system that was seized by DPS there at the home of Mr. Ozuna.
Mr. Woodwhite, can you review the indictment in CR 22-282 and let's investigate the spelling of the defendant's name in that cause also? I suspect it's going to be the same.
Yes, Your Honor.
And while he's doing that, Mr. Manning, can you spell his middle name for me again?
It is ELUETRIO.
Thank you, sir.
Judge, in cause number CR 22-00282, the middle name is spelled the same way. So we would make an oral motion in both of those charges to have the court interlineate the correct spelling of Mr. Ozuna's name.
No objection.
All right, the court will grant the state's oral motion to amend the indictment in both cause number CR 22-282 and CR 22-385 to reflect the correct spelling of the defendant's middle name, ELUETRIO, at ELUETRIO. And that court finds that's without objection from the defense. Court will set Mr. Ozuna for pretrial in the aggravated assault case 282 for pretrial hearing on February 9th, Mr. Manning?
Yes, Judge.
February 9th, to give the state more time to produce the security video footage. And the court will carry Mr. Ozuna CR 22-385 to pretrial on that same date.
Judge, I'm also ready for clearance.
Did you say Clarence Smith?
That's correct, Judge.
All right, court calls Clarence Smith, CR 22-285, 286, 287, 288, 289, 290, 291, and 292. Court shows that each one of these causes is set for pretrial. Go ahead, Mr. Manning.
Judge, I have gone over to the DD's office. I've reviewed the photographs, the interview. I've discussed those with my client as well as the paper discovery. However, I've recently received some potential evidence from a third party. I'm going to need to file a motion for funds on a forensic examiner for a digital device. And so I have not yet made that application. I've spoken to my client about that today. So I need additional pretrial so I can file that motion and secure those funds and we can get that procedure begun.
All right, court will grant the request for an additional pretrial hearing to February 9th in each case.
Mr. John.
Who is this, Mr. Manning?
Mr. John Baird,
John
ER
Baird.
22266.
All right, Mr. Beard is set for status. Go ahead.
Judge, this is a status on the competency evaluation that was supposed to be done by Dr. Compton. Her office assured me that she, as well as one of my other clients, was going to be evaluated November 22nd. I have sent a follow-up correspondence to her office and have not heard back. However, when I got to the jail today, I confirmed with my client that he has not been visited by Dr. Compton at this point in time. And so I'm going to reach out yet again and see if we can get some sort of movement on both Mr. Bear's case as well as Mr. Daniel's case, who was supposed to be evaluated.
And remind me, how is it that we got to Dr. Compton doing the evaluation? Was this a second opinion or a request
Judge,
other than?
This was actually a motion for competency filed by the state, and that was done in the misdemeanor case, which is by Judge Winters.
There's a misdemeanor that predated this one, and it was filed in that, I believe.
And so Dr. Compton was supposed to have the report back by November 22nd. And
No, Judge, actually, she was supposed to have the report back on November 18th. And when I contacted about the status of that for November 18th, I was told that she would be there on the 20th, and that hasn't happened.
Okay, all right, the court's gonna reset Mr. Baird then. I'm not gonna set him out to February. I'm gonna reset him to January 5th. If you're available, Mr. Manning.
I am.
That way, if Mr. Baird is found to be incompetent, we can get our orders to mental health competency restoration sooner rather than later.
Judge.
So January 5th for status on Dr. Proctor's competency report. I'm sorry, not Dr. Proctor, Dr. Compton.
Judge, I have plea paperwork. Mr. Shelton, there was an issue with his time credit that is being researched as we speak. It looks like Ms. Abney was able to confirm an additional 78 days and has sent the corrected judgment to probation for it to be printed out. So I'll go over that with my client. And then I also have Mr. Dennis James. That is the writ that was set. The 17-151 writ.
Are we ready on Mr. James?
Judge, yeah, we can do Mr. James.
Go ahead and bring Mr. James up. All right, this is writ number WR 22-108. James Dennis versus State of Texas. Go ahead, Mr. Manning.
May I call my client, please?
Yes, Mr. Dennis, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Dennis, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Okay, you can put your hand down, but you're gonna have to speak up so that I can hear you. If I can't hear you, then I can't give you what Mr. Manning is going to be asking for me to give you, and my court reporter will not be able to take it down. Okay, so make sure you speak up loudly and clearly. Go ahead, Mr. Manning.
Thank you, Judge. Mr. Dennis, you're here on multiple charges. What are those?
And the rest of the motor vehicle with previous conviction and child endangerment ×2,
And do you know what the bonds are for those?
50,000 and 100,000.
So 50,000 on each, or is that
50,000 on the 2 child endangerments each, and 100. Yeah, and 100,000, another 50,000 for evading arrest with a motor vehicle.
so your total was 150,000?
Yes, sir.
Okay. And when were you arrested on these offenses?
August the 28th.
And have you been in jail continuously since then?
Yes, sir.
Have you been able to afford any type of bond during that time?
No, sir.
Okay. Do you have any sort of assets you can use to put up for a bond?
Not anymore.
And did you have a job prior to being arrested?
Yes, sir.
And did you have any money saved up that you could use for a bond?
At the time I did, but I had to spend it on commissary.
Did you do you have any other types of assets like a vehicle or a home, bank accounts, anything that you could use to be put up?
Not anymore.
And by not anymore, please explain what you mean by that.
With me sitting here, I lost my vehicle.
And where were you living when you were arrested?
502 Backwood, Gilmore, Texas.
And did you own that home?
No, sir. My mother's.
Has she or anybody else been able to assist you in making a bond in this case?
No, sir.
And he, like you said, you've been in custody for continuously for over 90 days. Is that correct?
Yes, sir.
And you've been unable to afford any sort of bond or bond reduction if we got an agreement on that.
No, sir.
And you're asking this court to give you a PR bond. Is that correct?
Yes, sir.
Judge, I'd ask the court to take judicial notice of my client's application and the order of indigence and arrest.
All right, court will take judicial notice of the application for bail reduction filed in writ WR 22-108. Court will also take judicial notice of this court's finding of indigency for Mr. James Dennis. Any questions of the defendant, Mr. Woodwhite?
Briefly, Your Honor. Mr. Dennis, for the purpose of this hearing only, state would offer the affidavit of probable cause. Judge, I don't know the best way to provide this to the court. I believe Mr. Manning, have you been provided a copy of this?
I know that Mrs. Heisman discussed it, but I cannot recall actually viewing it.
Judge, do you think should I email Ms. Abraham and Mr. Manning? I don't want to jump this on Mr. Manning without him having the opportunity to review it.
Why don't I recall this case and y'all can figure out what y'all want to do on that exhibit, and then once y'all are ready, we'll move forward.
Yes, Your Honor.
And Judge, I have reviewed my communications with Ms. Heisel, and I did not receive a copy of the piece affidavit, merely a summary by Ms. Heisel. So I would request a copy of that before we proceed.
Yes, sir. Mr. Dennis, go ahead and have a seat and I'll recall your case here shortly.
Sir.
Ms. Tabraham, I noticed that Ms. Shundalee is logged in for the Zoom hearing with Smith County at 1:30, but I haven't seen the Smith County Jail for her client. Don't know if we want to check on that or just wait patiently. Either way is fine, but
I just want to make sure.
Mr. Manning, I'm going to take up an inmate that's being housed in the Smith County Jail for just a moment.
Judge.
All right. And I'll be right back with you. Are you Mr. Cunningham, sir?
Yes, sir, Your Honor.
All right, thank you. My name is Judge Chris. This is the 294th District Court in Van Zandt County, Texas. And Miss Shundley, your attorney, is logging in. We're gonna give her just a moment to get connected.
Yes, sir.
Hello, this is Shonda Lee.
Good afternoon, Miss Lee. How are you?
I'm well. How are you?
Doing fine. All right, this is cause number CR 22-212 and F-19-7, State of Texas versus Jeremy Quinn Cunningham. Show that we are set on a docket call on burglary of a building, and then also the motion to adjudicate on the state jail felony that was transferred up from the county court at law, I believe. Any announcements, Ms. Lee?
Yes, Your Honor. We have reached a plea agreement with the ADA, but we reached that on Monday, so there wasn't any time to to get everything together. So I would like a reset so that we can do the plea.
Okay. And so is there any specific amount of time that we need to have Mr. Cunningham brought back? We'll need to do a bench warrant for Smith County.
Not as far as I'm concerned. I don't know if Smith County might have an issue.
Okay. Mr. Cunningham, do you know how much, and I don't want you to disclose anything regarding any pending charges or cases that you have in Smith County. However, do you have an idea of when your business might be concluded there?
It's been concluded, sir.
It has been concluded. Okay.
Yes,
All
sir,
right.
Your Honor.
All right. Thank you, Mr. Cunningham. So what we'll do, Ms. Lee, is let's see. Today is first. We could probably bench warrant Mr. Cunningham here in 2 weeks on December 15th, if you're available, Ms. Lee.
At 1:30,
Yes, it'd be at 1:30.
I am available.
Okay, so what we'll do, Mr. Cunningham, is I'll issue a bench warrant to Smith County for us to come over there and pick you up. We'll bring you back and we'll do the plea here on December 15th in the afternoon at 1:30. Okay, sir?
Okay, I appreciate it, Your Honor.
You're very welcome. And Smith County detention staff, if they're not in there, let them know I said I appreciate their assistance very much.
Yes, sir, Your Honor.
All right. Thank you, Mr. Cunningham.
Yes,
Thank
sir.
you, Ms. Lee. We'll see you all on December 15th.
Thank you, Your Honor.
You're welcome.
Bye.
All right, Mr. Manning. Sorry about that. Go ahead, sir.
No
Who
problem,
do you,
Judge.
who do you have with you?
Mr. Shelton, and we have a plea ready for him.
All right.
And Judge, this will be both for his felony case number CR 2278, as well as resolving the misdemeanor possession of marijuana 2022-28.
And is the marijuana misdemeanor in my court or is that in Judge Winter's court?
It appears to have been filed in Judge Winter's court.
Okay. And is that going to be a plea on that case or a dismissal on that case?
This will be a 1245 on the possession of marijuana.
Okay, since it hasn't been transferred up to my court, I would just ask that you submit a 1245 letter to Judge Winter citing and requesting that that be considered with this case here. CR 2278. Mr. Shelton, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can lower your hand. Your name is Jeremy Tremaine Shelton, is that correct? And Mr. Shelton, I need you to speak up a little bit louder so my court reporter can hear you, okay? And Mr. Shelton, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation? Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
And Mr. Shelton, is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Shelton to be competent today, and have you explained to him his rights as they pertain to this case?
I have, Judge.
And do you believe that he understands his rights and the waivers he's making in this plea?
He does.
All right. Mr. Shelton, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. A state jail felony in the state of Texas carries a range of punishment of not less than 6 months or more than 2 years in prison and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
And Mr. Manning, what is the proposed plea?
Judge, Mr. Shelton, upon a plea of guilty, is going to request that punishment be assessed at 12 months TCJ state jail, $1,000 fine, $108 restitution, and we 1245 that possession of marijuana. He additionally has 160 days credit towards that sentence with $209 court cost and a $55 reimbursement fee.
All right, Mr. Shelton, you've heard Mr. Manning state the plea agreement. Is that the plea agreement as you understand it to be?
Yes, sir.
And that's what you're asking the court to approve?
Yes, sir.
All right, and the court finds that the proposed plea agreement would fit within the legal range of punishment. So, Mr. Shelton, at this time, how do you plead to that charge?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
Objection, states one.
State's evidence is admitted and the court does take judicial notice of Mr. Shelton's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
Just briefly, Judge, my client would like the court to know that he, upon his short stay here, has already achieved trustee status and requests that under Article 42A 559, he be given presumptive entitlement to diligent participation credit for the state jail facility.
Thank you, Mr. Manning. Court will take that into consideration. Mr. Woodward, can you give me the facts to support the plea?
Yes, Your Honor. Van Police Department notices a U-Haul that has been reported stolen going down Interstate 20. Police Department pulls them over, separates the defendant and a co-defendant, and speaks to both after Miranda, the warnings are given. The co-defendant who is driving states she is aware that she has kept the vehicle, quote, a few days past the rental agreement. She then notifies Van that there is meth and a pipe in her bra. Van goes to speak to the defendant and he tells them that the co-defendant has meth on her and begins to say, because it is mine, but trails off before finishing the sentence. Female officer arrives and retrieves the meth and the pipe. The lab tested 2.76 grams of methamphetamine.
Thank you, Mr. Woodward. Any objection to that, Mr. Manning?
No objection, Judge.
All right, based on the facts as presented to the court and the evidence, the court finds that there is sufficient evidence to convict Mr. Shelton of this offense. The court will follow the plea agreement between the defendant and the state. The court hereby convicts Jeremy Tremaine Shelton of possession of a controlled substance in penalty group 1, less than 1 gram. Court assesses his punishment at 12 months confinement in the Texas Department of Criminal Justice State Jail Division, orders him to pay a $1,000 fine, $180 court cost. I'm sorry, $180 restitution, $290 court cost, $55 reimbursement, and 160 days credit towards that sentence for the time that he has spent in jail on this cause. Court recognizes that the parties intend to dismiss cause number 2022-28 under section 1245 of the Texas Penal Code. The court will direct the parties to send that to the court that has jurisdiction of that case by filing. Mr. Shelton hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. And I will take into consideration once the state jail division emails me and notifies me that your file is up for review for diligent participation credit, the court will review that report, and that report includes educational endeavors that you undertake there at the state jail facility, in addition to any disciplinary history in your report. So the court will consider all of those things in addition to what Mr. Manning has said about you making trustee during your time here in Van Zandt County. Okay. All right. Good luck to you, Mr. Sheldon.
And Judge, I've had a chance to review the affidavit that was sent over for limited purposes of this hearing. We would have no objection to that, and we're ready to continue the hearing on Mr. James.
Okay. All right, then let's go back on the record.
Judge, I also emailed that to Ms. Tabraham. Has she provided that to the court?
Yeah, she did just a moment ago during that last hearing. So, all right, we're gonna go back on the record in WR 22108. James Dennis versus State of Texas. All right, and then the state has offered the probable cause affidavit supporting arrest as state's exhibit. Did you label that, Mr. Woodwhite?
Judge, I didn't, but I would label it as State's Exhibit 1 for the sole purpose of this hearing. Obviously not any further.
All right, there being no objection from Mr. Manning as to certifying that he's received it and had a chance to review, court admits State's Exhibit 1. Go ahead. Anything further, Mr. Woodwhite? Did you have any
No.
questions of Mr. Shelton?
No, Your Honor.
All right, anything further from the state?
Judge, we would agree that it's been past 90 days. Given the information provided in States 1, we would ask for conditions of pretrial release that the court feels are just in this cause. I don't have a specific request, but given that there are 2 children involved, I would ask for conditions regarding that.
What kind of questions?
Judge, I am unaware if Child Protective Services are involved. If they are, I would ask that whatever contact be limited to the CPS case. I guess I probably should have asked Mr. Dennis that. Judge, may I reopen briefly just for that purpose?
Well, Mr. Manning, do you have that information?
Judge, if I may just take a step out, my client, he said he sent me a letter, but I did not grab his file and the group of files that I had. So let me take a step back and get a refresher as to what he told me about that.
Sure, yes, sir.
Judge, I can answer that question for Mr. Woodwhite. There was a disposition on that case, and it was closed out by CPS.
Okay, and so who has custody of or conservatorship of the children at this time?
The mother.
And what's her name? Is it Whitney?
No, it's Aronia Mirmoni Haynes. That's MERAONIE. Haynes, Haynes.
All right, thank you, Mr. Green. Anything further, Mr. Woodwhack? So you're asking the court to issue conditions of pretrial release related to the children indicated in this abandoning or endangering a child. And you're asking, tell me again what it is you're asking specifically.
Judge, I would ask that he have, if the court feels warranted, no contact with the children. I believe they are his children. If they are, then supervised by the custodial parent who does have custody of them. I believe that would be sufficient. I'm not concerned overly about tampering, witness tampering, something of that nature. Just that this does appear to be a dangerous situation. He is charged with abandoning and endangering those children. Just to have another reasonable adult there to supervise.
Judge, you'd object to no contact, but would understand the court having a supervised visitation until this case is further resolved.
Okay. Anything further, Mr. Manning?
Judge, I would note that Mr. Mr. Dennis is going to be once released from here from Van Zandt County, will be going over to Smith County to finish up some business over there, and so he will not be getting out directly, but will be being transported over to Smith County.
Okay, and Mr. Dennis knows, and I don't know what kind of business he has in Smith County, but Mr. Dennis knows that once the court grants the order, or once the court signs the order allowing Mr. Dennis to post either a personal recognizance bond or a personal bond, that he will no longer be entitled to any credit time, though he may remain in custody in Smith County for some time, undeterminable by this court.
That's correct, Judge. We have discussed that.
Okay. All right, then the court will take this under advisement, and I will issue a ruling at the conclusion of the docket today, and will provide written notice of the ruling and any conditions of pretrial release to both defense and the state.
Thank you, Judge. And just by note, I did, for whatever reason, I don't believe I received. I know that Mr. Roberts was able to be given conditions and released from our Tuesday hearing, but I don't believe I got actual notice of those. So if we could make sure that I get those, just so I don't have to follow up with jail tomorrow.
Yes, sir. I'll make sure that you receive the order and any conditions that will be attached to it.
Thank you, Judge.
You're welcome. Let me review that here. Thank you. That's helpful.
And Judge, I believe that concludes my business. May be excused.
Yes, thank you, Mr. Manning. Appreciate all your hard work today.
Thank you, Judge.
They bring my females, Judge.
They're bringing your females?
Yes, sir.
All right. Are you ready, Mr. Schmidt?
Yes, sir, I'm ready. We've got a plea on Amanda Meek and an announcement on Tasha Messick.
All right, Ms. Messick, CR 2185.
Judge, this is a motion to revoke. We were here on Tuesday. We reached an agreement with the state and that required paying off balances. And as the court may recall, we believe that our balances were like a little less than 3,000. But the court made us aware that you wanted the probation fees paid off as well. I got those balances from probation and the total was somewhere like $4,100. They have 3,000 ready to pay, but we want to be able to pay it all off and be done. So their Ms. Messick's representative is getting together the remainder of that balance. So we'd ask that this be reset either on your next contested docket sometime next month. We anticipate having it resolved by then, and hopefully we can satisfy all those payments if we don't.
Okay. Court will set Ms. Messick then for hearing on January 26th. And if those financial obligations are taken care of before then we may be able to get her on a quicker docket. And
Yes, sir.
remind me, the agreement was for her to pay off. Was it for her to be continued or to be terminated?
Terminated, Judge, we have.
She- She's expired, Your Honor. Her probation is over, so we were going to allow her to successfully terminate if once the financial obligations are met.
Okay, so if that money gets paid before January 26th, notify the court and we may be able to expedite the paperwork and have her released.
Yes, sir, thank you.
You're welcome.
Well, you talked to the guy. Yeah, you can tell him. Yep.
All right, Amanda Meek, CR 2218, and you said this is plea today?
It is, Judge, and the terms of the plea are that on a plea of true, the judge, court will adjudicate her guilt and should be sentenced to 5 years TDCJ or to pay the balance of her financial obligations, which appear to be fines. I think that they, on the judgment, the prior assessed fees are, I think, lumped all in that one spot. I'm not certain, but I don't have a court cost sheet, but it says 3,605 on fines, $50 court cost. And she has 469 days credit time.
469?
Yes, sir.
And Mr. Woodwhite, can you do me a favor? I don't have access to my LGS, so I can't pull up the motion to adjudicate. I always like to display that, show it to the defendant, and allows me some preliminary information also. Would you mind displaying that on the screen? And you should still have, let's see, sharing ability. Just the most recent motion to adjudicate. While he's doing that, Ms. Meek, if you'll raise your right hand, I'm going to place you under oath. You are Amanda Robin Meek, is that correct? Ms. Meek, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can put your hand down. Great, thank you, Mr. Woodwhite. All right, Ms. Meek, for the record, you are represented by Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's representation of you?
Yes, Your Honor.
Do you feel like you've had enough time to meet with him, talk with him about your case, and have all of your legal questions answered?
Your Honor.
Is there anything about the paperwork that you've read over and signed today that's part of your plea agreement that you do not understand?
No, Your Honor.
And I see here that you appeared before the court on September 15th, 2020, and you pled guilty to the second-degree felony offense of burglary of a habitation. Court heard the evidence on that day, found that there was enough evidence to convict you, but the court deferred a finding of guilt and placed you on community supervision for 5 years. And then it was during that period of your community supervision that the state has filed this motion to adjudicate and revoke. And Mr. Woodwhite, can you show me the total number of counts alleged? Thank you. So it appears that the state has alleged 7 separate counts of ways that they are alleging that you have violated your community supervision. Have you had ample time to review that motion with your attorney, Mr. Schmidt?
Yes, sir.
And Mr. Schmidt, is it your client's intent to plead true to all 7 counts?
Yes, Judge, we would wait formal reading and enter a plea of true on also.
Great. Thank you, Mr. Schmidt. I appreciate that. All right, so Ms. Meek, having reviewed the state's motion at this time, I would ask you, and let me ask you, Mr. Schmidt, you do obviously believe that Ms. Meek is competent to enter into this agreement today and that she understands the repercussions of her plea. Is that correct?
I do, Judge.
Okay. And Ms. Meek, at this time, I'm going to ask you, how do you plead to counts 1 through 7 as alleged in the state's motion? Are those counts true or not true?
True, Your Honor.
And are you telling me that each one of those counts are true because in fact they are true? You're not just pleading true to get a certain plea agreement. Is that correct?
Correct, Your Honor.
And Ms. Meek, has anyone threatened you, forced you, made you feel like you had to plead true to any count today?
No, sir.
All right, the court will accept the defendant's plea of true. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
That's admitted into the record and the court takes judicial notice of Ms. Meek's judicial confession. Anything further from the state,
No, Your Honor, we would rest and close.
from the defense?
Yeah, briefly, Judge, I would, for the record, let the court know that the state proffered 2 different offers and this week had the option to choose from both, and this is the one to chose. So nothing further other than that, ask the court to follow the agreement.
Well, and just for clarity of the record, in case there's ever a question, what was the other offer that Ms. Meek declined so that she could accept this one?
Judge, the state had agreed to withdraw and continue with amendments to Ms. Meek's community supervision, including a stay at the substance abuse felony punishment facility. And after consideration, she determined that it was in her best interest to accept the revocation of 5 years.
Thank you, Mr. Schmidt. Is that true, Ms. Meek?
Yes, sir.
All right, thank you, Mr. Schmidt. All right, then based on the evidence and the defendant's pleas of true, the court finds that Ms. Amanda Robin Meek has violated the terms of her community supervision. Court finds all 7 counts to be true. Court will follow the plea agreement reached by the defendant and will follow the recommendation of the state. The court hereby revokes the community supervision of Amanda Robin Meek, sentences her to convicts her and sentences her to 5 years confinement in the Texas Department of Criminal Justice for burglary of a habitation, a second-degree felony. The court will order her to pay the balance of her financial obligations, and the court awards her 469 days towards her sentence for the time that she has spent in jail on this cause. Ms. Meek, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Good luck to you.
Yeah. Well, I think that's all I have, Jim.
Thank you, Mr. Schmidt. Appreciate your work today. All right, I think we are waiting on Mr. Weiner is in the waiting room, it appears, but we do not have Henderson County Jail with Mr. Dusty Rhodes. So I'm gonna step off to talk to Ms. Taperham about that and then get Mr. Weiner in and we'll move forward, Mr. Woodward.
Thank you, Your Honor.
Thank you, Deputy Everett. I appreciate you. Is there anything else that we need to do at the jail?
No, there's not.
Thank you, sir. Appreciate your work.
Yeah, but whenever he goes off, I'll need you to come back and redo it. The mic. Oh, okay, all right.
So do we need to do anything else? Are you good?
You got the mic on?
Everything shows to be on.
We can hear you, Dusty.
Okay, okay.
Are you
All right.
good? Okay.
All right, thank you.
Mr. Woodwhack, are you ready?
Yes, Your Honor.
All right, this is cause number CR 1326, CR 22249, State versus Dusty Lynn Rhodes. Are you ready? Go ahead, Mr. Reiner. I'm sure that we're set for docket call.
We are, Judge. So if you recall, this is a relatively complicated case. Mr. Rhodes has newer cases, but he also has an older case. At the last setting, you agreed to reduce his bond on the older case. It was the one that was kind of complicated where there should have been a hold when he went to TDC, but there wasn't. And so I know you probably don't like hearing this, but he also has felonies in 2 other counties. And so I'm working to try and resolve everything, Judge. I do think we have an agreement on the old state jail felony. Essentially time served on it. I was hoping that we could enter into an agreement, not today, but at least to get that one knocked out so that all we have are the newer cases. I wasn't sure if the court would entertain that or not.
Entertain accepting a plea agreement on the CR 13 case and not the CR 22249.
Yes, give us a little more time to try and resolve the newer case. But you know, I think that's just maybe a showing good faith that we're able to plea at least the old one. We're still working to try and resolve the new one. Does that make sense?
In a roundabout way. I mean, if you're just asking for more time, I'll grant you more time.
I would like some more time, but would you let us plea the old case separately from the new cases, or would you want them all to be resolved at one time?
I don't know. I'd have to think about that. So
Okay.
let's just reset it, and then if y'all come up with an agreement, then y'all set it, and we'll hear it then.
Oh, an agreement on everything or just on the old case? I'm sorry.
On whatever y'all present.
Okay, I appreciate it, Judge. What dates do you have?
I'll reset you a little further out so you'll have more time.
Thank you.
Let's look at February 7th or 9th or 21st or 23rd.
Let's do the 21st, please, if that's okay, Judge.
All right, court sets Mr. Rhodes for docket call in each case on Tuesday, February 21st.
Okay, and I will speak with the state, and if we're able to reach an agreement on the old case, I'll reach out to Patty and see about getting that set sooner.
Sounds like a plan.
Thank you very much, Judge, and I appreciate you letting me appear late.
You're welcome. Thank you, Mr. Rhodes. Appreciate it. And tell the Henry County Zoom staff, I'm not sure if y'all were logged into a different one. We called over and we were here, but we didn't see it. So I didn't know if y'all were in the right Zoom or not.
They were logged into a doctor's visit for somebody else. I had to call them back.
Okay. All right. All right.
Hopefully you got good news, Mr. Rhodes.
Yeah. Hopefully you checked out good. So.
All right.
Thank you.
Maybe
Yes.
maybe
Thank you,
Thank you.
yes.
All right.
Thank you, Mr. Woodward. I appreciate your work today.
Thank you.